Good evening. Thank you for joining us. I'm Kim Knox, President of the League of Women Voters of San Diego. I'd like to let you know about some upcoming events. Next week, we will return to Tom Hand's Lighthouse Restaurant for lunch with the League on the topic of gun violence prevention. It's been 3 years since we did a luncheon there, but it used to be a regular monthly occurrence. It is sold out at the moment, but you may put your name on the waiting list for this event. This is Wednesday, April 19 at 11:30 a.m. So if you join the waiting list, you'll be notified if a seat opens up, and also the video of the event will be made available on our website the following day. On April 26th at 6:30 p.m. on Zoom, we will be selecting issues for local league focus. This is when you can let the San Diego League know where it should focus its energy and resources over the next year. So you can register for events on our website, lwvsandiego.org, and I'll put that in the chat. All right, last thing, the League is an all-volunteer organization, and we greatly appreciate the donations made today during registration for today's events. For anyone else who would like to donate, I'll put a link in the chat. Thanks very much. Now, Jane Andrews, our events director.
Thank you. Important reminder. Okay, about a year ago, the San Diego League had an event on the Supreme Court that was so well received that we decided to have another. As we approach the time of year when the Supreme Court decisions on important issues are expected to come down, getting good information about the context and debate about them is important preparation for understanding the implications of the justices' decisions. The Supreme Court has certainly been in the news lately, so we think our timing is good for this topic. Today, we are grateful to have both Dan Vicuna and Glenn Smith discuss key issues before the Supreme Court. Dan Vicuna has been a staff member and attorney at Common Cause for the last 9 years. Based in Los Angeles, he's the national redistricting manager who specializes in legal issues regarding constitutional challenges and partisan gerrymandering. He got a BA in political science at UCLA and JD at American University, Washington College of Law. Dan will focus on voting rights issues before the Supreme Court. Glenn Smith, who was with us last year, teaches constitutional law at both California Western School of Law and UCSD. He has taught law for 38 years. He got a BA in public affairs at George Washington University and JD at New York University School of Law. Glenn will focus on cases that involve questions about what is settled law, which the Supreme Court could overrule. And time permitting, he will also reflect briefly on the aftermath of last year's Supreme Court decision on gun rights. Both of our speakers are sharing their slides with us, and they will be available after the talk. After their talks, Kim Knox and I will be fielding attendee questions for our speakers. So over to you, Dan.
All right, thanks so much. I really appreciate everybody joining. Let me get the screen sharing going here. Okay. All right. So I'm going to get into two big cases that the U.S. Supreme Court heard last term and will probably decide sometime over the next couple of months. One is Moore v. Harper, the other is Milligan v. Merrill, and they're both significant voting rights cases regarding redistricting. So I'm going to just dive in. Excuse me, that's Merrill v. Milligan. I got them backwards. But I'm going to dive in first to talk about the case that Common Cause is actually a party in, Moore v. Harper. All right. I'll give you a little background on kind of how we got to where we are first. So in 2019, Common Cause brought a case in federal court where we asked the U.S. Supreme Court to rule that partisan gerrymandering was a violation of the U.S. Constitution. We said it's offensive to 14th Amendment equal protection. It's offensive to First Amendment free association. And we want the federal courts to do something about it. Unfortunately, that case didn't work out for us. The U.S. Supreme Court, in a split 5-4 decision, said that federal courts would not police partisan gerrymandering. They said there were no judicially manageable standards to determine what a partisan gerrymander was. We thought that was strange, since the district court in that case figured out a standard. A couple other district courts figured out a standard in a few other states to strike down maps on the same grounds. But you win some, you lose some. So that was the bad news. The good news was that in the decision that the Chief Justice authored, the justices were very clear that state courts could set rules for partisan gerrymandering and enforce those rules to stop the manipulation of voting districts on partisan grounds. So we took them up on that offer. Common Cause, again, it was one of several cases that ended up being consolidated in North Carolina, where we decided to go to state court to challenge both state legislative and congressional maps as partisan gerrymanders that violated several different provisions of the North Carolina Constitution. We said that they violated the Free Elections Clause, which had been used in Pennsylvania and in the last cycle in North Carolina to strike down maps, but also they also were violative of the state constitution, equal protection laws, and also some First Amendment-like protections, free association as well, again, under the state constitution. And the North Carolina Supreme Court agreed with us and struck down the maps as violating North Carolina state constitution. Just to give you a sense for what the maps look like, in a state that's, the politics are pretty split, right? It's got a governor, attorney general that are Democrats, a couple of U.S. senators that are Republicans. It's been pretty close in presidential elections over the last few cycles. But Republicans in the legislature drew a map that would have resulted in 10 Republican seats and 4 Democratic seats. Not at all reflective of the state. And once the the North Carolina Supreme Court struck the map down, ended up with a congressional delegation. Here it says most likely seat allocation. This ended up coming to fruition. It's a 7-7 delegation right now on maps that a special master drew after the state Supreme Court struck down the map. So then what happened next is where it gets a little hairy. The North Carolina legislators who drew the original partisan gerrymander appealed that state court decision to the U.S. Supreme Court, and they did so arguing a theory called the independent state legislature theory. And what this really boils down to is the idea that the U.S. Constitution prohibits state courts from exercising any oversight, exercising their judicial authority over what state legislators do when it comes to federal elections. So basically, somehow, the U.S. Supreme Court grants legislatures superpowers that they can use to do whatever they want over federal elections, including drawing manipulated voting maps, and that state courts are powerless to stop them. It's incredibly radical. It goes against history, logic, legal doctrine. It's pretty offensive to all of those things, but that's what they're going with, and that's what they argued in the U.S. Supreme Court. So let's talk a little bit about what would happen if that theory, independent state legislature doctrine, were given a rubber stamp by the U.S. Supreme Court. Legislators would be free to manipulate election rules. It would allow direct assaults on voting rights, and again, state courts, their hands would be tied to engage in the standard checks and balances that are fundamental to our system, that were built into representative democratic governance since the founding. It would provide state legislators free hand, really to elect themselves, elect their party in perpetuity by manipulating our election rules. Kind of more specifically, we've kind of gamed out like what could this mean in terms of what legislators would actually be empowered to do. They could make it easier to create barriers to vote, maybe target strict photo ID laws for voting that target certain populations that they don't think will vote for them, kind of discriminatory practices. Again, in this case specifically, drawing rigged voting maps that may be very clearly designed to benefit a certain set of incumbents, or in North Carolina's case, more likely one political party over the other. It would be allowed, again, kind of carte blanche to just do whatever they'd like, and have the power without any kind of oversight by state courts. And there's also a risk of it casting doubt on fair election results. We've seen some version of this used, of this legal theory, used in some cases when Donald Trump was sort of perpetrating the big lie. This theory was used. Now it's a little bit of a different area of the law, but who knows what it could open the door to. We've seen a lot of manipulation of elections through the purging of voting rolls. Excuse me, being very, very quick to target populations for removal from the rolls if those in power believe that they may not get their votes. You've seen the use of kind of cutting popular early voting options. In North Carolina, there was an attack on souls to the polls, sort of Sunday early voting, in which a lot of people would kind of go to church and then all go vote together, which is kind of a clear targeting of Black populations in the state. Again, that's something that was struck down that may have a new life if state courts cannot intervene and stop that. And then fewer protections against voter intimidation, just making it easier to engage in activities that scare people from even showing up. And again, state courts would have to sit by and let that go as it pertains to federal elections. This is the bottom line. The standard oversight that is the role of courts in our system, to sort of theoretically, right, think beyond kind of the passions of the moment, the partisanship of the moment, and concern themselves with what actually strikes at the heart of fundamental rights. Courts would be stripped of that ability when it comes to federal elections. And we know that, especially in the last, kind of dozen years or so, there's been a huge push to use voting rules, manipulate them in a way that benefits a certain party or candidates. And a victory for North Carolina's legislature in this case, and especially one that includes a approval of independent state legislature doctrine, would just be a huge threat to our voting rights. There's a lot of opposition to this theory because it's so dangerous, and a ton of amicus briefs filed in support of our side, in support of state court oversight of what legislators do when it comes to federal elections. I'm just going to point to sort of one of these amicus briefs because it's so extraordinary. The organization that represents all chief justices in all 50 states, so imagine as liberal as can be and as conservative as can be, they rarely weigh in with amicus briefs, but they decided to sort of get off the bench for this one and play here. They filed an amicus brief that urged the court to allow the courts they sit on, state courts, to engage in the standard judicial oversight that is fundamental to our system of checks and balances. So they decided it was time to weigh in for something to oppose a theory that was so radical, so extraordinary in its scope and threat. I think it's important to remember that while this case involves a Republican legislature discriminating against Democratic voters for the purposes of partisan gerrymandering, state courts played a role in several different states. State courts struck down maps as partisan gerrymanders, Democratic gerrymanders in New York and in Maryland, in addition to striking down Republican gerrymanders in Pennsylvania and North Carolina, the heart of this case. So it's really just about voting rights for all of us, ensuring that every voter has a voice and that their vote counts. So we just want to make sure to really drive home this is not about partisanship from one side or the other, because the work we do in Democratic states, and our league is our partner in all of these places where we do it in Democratic states, they push back and are pretty willing to manipulate districts as well for their own benefit. Now let me switch over to the other case. We are not a party in this case, but I did want to give kind of an overview because it's so very important. Merrill v. Milligan, I think it's captioned Allen now because of a change of the Secretary of State. This is a case about the Voting Rights Act and interpreting the Voting Rights Act when it comes to redistricting. So this case comes out of Alabama, which has 7 congressional districts. and the legislature really packed Black voters into just one district, one of the 7 districts, despite the fact that more than a quarter of the population is Black, for the purpose of ensuring that they really had no ability to affect the outcome in any other district, really keep them focused in or packed in just one. The trial court, after extensive fact finding, found that this was a violation of Section 2 of the Voting Rights Act. This was a clear effort by Republican legislators to keep Black voters packed in just one place so that they couldn't win in a second majority Black district. And the trial court really saw through what legislators were attempting to do. Just to talk a little bit about Section 2, kind of where the state of the law is now, and what kind of threat this decision may pose to it. So Section 2, the key part of this, sort of on the slide, is that it results in a denial or abridgment of voting rights. Previous to this, the problem was that a lot of that voting rights law related a lot to intent, or courts had started to interpret a requirement that there be intent to discriminate, which is very hard to prove. There was a time in America where white dominated legislators would be sort of loudly and proudly racist and vocal about it, but that time is really kind of past, and only a fool of a legislator would say it out loud. So this is the focus of Section 2 is really about what's the result, not sort of requiring a plaintiff to prove what's kind of in somebody's heart. And again, so the trial court struck down the map and determined under a case Thornburg v. Jingles, which I'm going to talk about in the next slide, that a second majority Black district was required to be drawn. So let's talk a little bit about what the rules are for redistricting under the Voting Rights Act now. There are several keys that you need to get into the courthouse, which I've demonstrated here not so subtly. The first prong of Jingles is really determining whether a minority group, a community of color, is it big enough, is it compact enough that you can that it can be the majority of voting age population in a reasonably configured district. And that's going to the reasonably configured part of this is going to come up in oral argument, which I'll talk a little bit about in the next slide. But basically, is it big? Is there enough people there where you can really make a district that's majority minority? Second Jingles prong is a minority group politically cohesive. Just means, do they vote the same? Because if you put a minority group together and they're split 50-50 in their voting patterns, then it's not going to create an effective district that's going to allow that community to vote in their candidate of choice. The third prong, does the majority group consistently vote as a block to defeat the candidate supported by minority voters? Pretty straightforward. Do the white voters of that community also vote cohesively in a way that makes it impossible for that minority to elect their candidate of choice? And so those are the prongs that are all kind of grouped together in the law. And then sort of a separate key, the final key to get in, does the jurisdiction have a history of racial discrimination? So that's kind of what Jingles is. The current state of the law when it comes to the Voting Rights Act and redistricting, not easy, but what the plaintiffs or what the defendants in Alabama want to see is to make it even harder than this, which is why I'll talk a little bit about how oral argument went. Right, Justice Kagan noted to the parties that I think to the Alabama Solicitor General that this case, it's easy under Jingles. It's very clear that the population is large enough, concentrated enough, the Black population in Alabama, to create a second majority Black district. And clearly, Republican legislators had a reason for doing that, for probably a partisan reason for engaging in racial discrimination. Defendant Alabama seeks a new framework for the Voting Rights Act that would make it very, very difficult for plaintiffs to win under Section 2 of the Voting Rights Act, which is basically, if a legislature draws districts in a race-neutral manner, then that's the end of the inquiry. That they've adhered to the Voting Rights Act, even though the concentration of the population would allow another majority-minority district. Justice Alito, thinking that might be a bridge too far, talked about another approach that, again, would be problematic. Maybe not as problematic as Alabama's, but problematic in its own way, which is that if a district is we're talking about the reasonably configured part of that first prong of jingles, which is the community big enough, concentrated enough to draw a reasonably configured district. Justice Alito proposed a definition is that would it be considered reasonably configured if a quote unbiased map maker would draw that district. So the Supreme Court, which doesn't seem to be particularly offended, at least in its partisan gerrymandering cases, with the crazy kind of spaghetti sticking out districts, weirdly shaped districts that are clearly manipulation of voting maps, will suddenly get, very strict about shape when it comes to protecting the rights of people of color in redistricting. So we don't know where that's going to land. Just like Moore v. Harper, most of the decisions, the most controversial decisions, tend to come out near the end of the term. Could be the end of June, but we'll probably starting next month, we'll be getting ready to look for those to come out. So we'll see. And that's it. That's the basics on these two important voting rights cases, and happy to take questions after the next presentation.
Thank you, Dan. Let's turn it over to Glenn.
Thank you very much. That was a great presentation, Dan. I learned a lot, and I always appreciate it when I do, and I know our rest of our audience did. So welcome, everyone, and thank you so much for being here. I love one of the things that's made my long teaching career so fun is getting to talk to people that are not students that are, having to take exams and pass the bar and all that, but who are just interested in these issues that I'm interested in. It's just a pleasure to be with you. I use as my way to do these slides, I put lots more information than possibly I could cover or that will be on your exam later. Just kidding, there won't be one. But not because I'm expecting everybody to, soak it up, but I know that when I sometimes speak to groups like this, there's a few people out there who really, really, really want to delve into it and understand the even deeper context, get into the weeds. And so I, as pointed out, have shared this this slideshow at a popular price for free, and you're welcome to dive into it and look at some of the slides that I will not be looking at. So I have taken on as my goal to talk about two cases that really, I think, are the most prominent, biggest high-profile cases, other than the Moore versus Harper one, and to a certain extent the Alabama case that Dan talked about at the end of the term. And if I have a little extra time, what I want to do is talk about a third case that was actually decided, it was real high-profile last term, but which is already having some implications nationally on a very important topic that the league is going to be talking about very soon: gun rights and gun regulation. What I like about this area is it shows us something that we may not always keep in mind. Some people always think that the court decides something, and it does, but it often, what it decides just starts the process going. It opens up the need for lower courts and lawyers and common cause and the league and all kinds of organizations to be involved in, all right, what's the next thing? How do we deal with these other issues? Anyway, let me dive right into it. I just want to also say my email address is right here, and I'd love to hear from anyone that has a question out of today's presentation, or finds an article or something they think they want to share with me. I really appreciate that. Okay, so I'm going to talk about two, as I say, high-profile cases: the affirmative action cases that involve Harvard and the University of North Carolina, and the religious freedom versus anti-same-sex discrimination case, the so-called website designer case out of Colorado. And then if I have any time, I'll talk about last term's New York State Rifle and Pistol Association versus Bruen, which immediately invalidated San Diego's concealed weapons permit system. And as a result, San Diego's sheriff is now issuing substantially more concealed weapons permits than it did the office did before, but also has, because it significantly changed the standard for reviewing gun control cases, has led to a whole bunch of lower court challenges being revitalized. One of the gun rights advocates called it a chance to do a do-over on a bunch of cases. And many of those cases, as I'm sure many of you know, are centered right here in San Diego. especially one particular district judge is a lightning rod or a magnet for those cases. All right, so let's talk about the affirmative action cases. And this is a case where the court, as you can see, this is an excerpt from the issues raised by the parties. The Supreme Court is being invited to, again, after last year's major Dobbs decision overruling 50 years of abortion rights cases, being invited to overturn precedents about affirmative action in education and in admissions from 2003. So not only is this such an important issue in terms of racial justice and full participation in society and education, but it's also, I think, a real question about the court's legitimacy. Is it going to get a reputation for, once again, overruling a case in many people's views, not because the precedent is archaic and grossly wrong, but because the court just disagrees with it. And so there's both the interesting legal issues that flow from it, and also some real legitimacy issues. And if you've ever heard me talk before, I keep emphasizing that the Supreme Court, even though they're life tenured, even though they technically are not subject to democratic accountability in the same way that elected officials are, really does need to care about the public perception that it is not just a third branch of politics. And so I think that's involved here as well. But again, an organization that cherry-picked the Harvard program and the University of North Carolina because they were respectively a private school that was under the Federal Civil Rights Act and a public school under the Equal Protection Clause, has gone in with both barrels blazing and said, all right, never mind trying to subject the programs at Harvard and University of North Carolina to current standards. You should overrule Grutter and Gratz. And basically what Grutter said, I have a slide, I'm not going to get into all this, but basically what Grutter and Gratz said is that in meeting the strict scrutiny standard, which the court earlier said that even affirmative action, even if government's discriminating, quote unquote, based on race for a good reason rather than a bad old reason, it has to show a compelling interest. And for most jurisdictions outside of education, the compelling interest is remedying past discrimination that's been demonstrated in that jurisdiction. And it's a tough standard. But in the area of education, the court opened up a second compelling interest that can be used for undergraduate and graduate admissions, which is achieving a critical mass of diverse entering class. And that's, Harvard and universities and graduate programs across the country who didn't have a past history of discrimination, have consistently used that interest and built affirmative action programs around it. Again, basically, the argument from the opponents follows the standard playbook that the anti-abortion rights challengers did in the Dobbs case, which is that the precedent is not just wrong, but grievously wrong, that it has spawned all kinds of negative consequences. They talk about, for example, Asian Americans being stereotyped and penalized, minority students being stigmatized because people think that they only got into the school because of affirmative action, et cetera, et cetera. And then finally, that the Grutter and Gratz cases have generated no legitimate reliance interest. That's one of the factors that the court looks at to figure out, even if a case is wrong and might otherwise meet the standards for overruling, if there's been a lot of reliance on it. And they said, well, no, there hasn't been a lot of reliance because universities should have known that their programs are cruising for a bruising, and they can change them. And then the court, as an alternative argument, the challengers go, okay, even if you're not going to overrule past precedents, court, you should find that Harvard's program fails the strict requirements because, and you can see these here, one of the requirements that both Harvard and UNC supposedly have failed, according to the challengers, is that they have violated the rule that you can't use race for admissions if you could achieve a critical mass of racial diversity without using race, by using, say, socioeconomic factors or the fact that this applicant is a first-generation college student or something like that. And so there's arguments, get rid of Grutter, but if you don't, we win even under the current standards. And there's a little bit of, I gave you some highlighted quotes from the brief, those of you that want to dive into it, talking about that both universities award mammoth racial preferences and their unthinking and stereotypic and basic and blatant violations of individual rights. And then there's the arguments from Harvard saying, no, the precedents are correct. They were correct when they were decided. They fit the text and the history, which the court is increasingly interested in, of the Title VI of the Federal Civil Rights Act. Diversity is a compelling interest. It's been applied correctly, and the standards are workable. There's no more uncertainty about this standard than there is about any other kind of legal issue. And then they defend their own program as just not having any of the failures that the challengers attribute the program to. And then here's UNC, which again, the UNC case is really about whether there are race-neutral alternatives and that UNC is willfully ignoring. So what are the main takeaways from this case? First of all, assuming that the court will not overrule Grutter, the 2003 precedents, and that may be a big assumption. It did appear, Dan knows you can't always read oral arguments as an indication of where the court's going to go, but it seemed that there was a fair amount of interest among a majority, if not 6 justices, to overrule those cases. So again, I fear that this will be yet another case where the court has overruled a precedent on at least arguably dubious grounds. But even if they don't overrule it, they're going to be involved in a very complicated fact-bound case. If you look at the briefs, for this, and those are available on SCOTUS blog and online and all that these days, you'll see all kinds of maps and computer models and all kinds of very complicated factual questions that district courts and the appellate court and all that dealt with. And so the Supreme Court would have to dive into it. Speaking of lower courts, this is really a test of how much the court defers to lower courts. But one of the divisions of labor between the Supreme Court and lower courts is the lower courts are closer to the factual situation. In this case, the Harvard District Court, the case with the district court with the Harvard case, did 15 days of trials and brought in all kinds of experts. UNC, the court dealing with that issue, had an extensive factual development. So the normal rules of deference should apply. We'll see if they do. Of course, it'll have a huge impact on academic and institutional diversity and racial equity and social justice. But as I mentioned, there's also a question about what another overrule does to the court's prestige, perception, etc. The second case I want to talk about is a case that you may think, wait a minute, this is deja vu. I thought I heard this before. Wasn't there something about a wedding cake and a baker who made a cake? But cakes, generally specialized cakes for wedding, but refused to make a cake for a same-sex marriage and was accused of violating the public accommodation laws in this state, Colorado. Why are we still talking about that? Well, the answer to that is that the court in the Masterpiece Cake Shop case decided the case very narrowly based on very specific, discriminatory, in the court's view, facts about the way the Colorado authorities dealt with the cake baker. So we're back with the website designer, Lori Smith, no relation, 303 Creative LLC, who is claiming that her sincere religious freedom means that she can't acknowledge or participate or approve of same-sex marriages, and she's being required by the Colorado public accommodation law to be willing to do a wedding website for a same-sex couple on the same basis as an opposite-sex couple. She's being compelled to speak and to support views that she doesn't agree with. If you're wondering why I scratched out this the other issue here, I wanted to point out that although the parties in this case wanted to raise not just the compelled speech First Amendment issue, you may not have heard of that, and I'll talk a little bit about that. They wanted to raise a question about the free exercise of religion, a case that the court has been, an issue that the court has been very, very active and interested in. They wanted to argue that, never mind as a compelled speaker, but Smith has the same right as any sincerely religious person, has the right to not be forced to give up her religious views by the source of even a generally applicable and neutral law. The court rejected that, as a court can do. It can pick and choose what issues it wants to take. It can even rewrite the issue that the parties have to deal with, and it did that here. So I want to emphasize, this is not technically about the question of what's the ultimate balance between religion and equal treatment in the marketplace, which is the ultimate really difficult and gnarly issue that broods over this case. But it's not technically an issue. There's a big free speech issue, and the court could do a lot of damage even in just the free speech area. But as often happens in these cases, the bigger issue is kind of brooding over as a cloud on this issue. And even though it's not technically being argued, how the court decides this case could send a signal about how much it values the free exercise of religion. So to make, I think you all know what public accommodation laws do. They have a long history, as pointed out by the US Solicitor General, who supports the Colorado Commission in this case. They have a long history since the Civil War of making sure that regardless of race and other protected statuses, including sexual orientation in Colorado, and by the way, in California, that people can't that people that are provide goods and services publicly can't discriminate. Basically, there's a little corner of free speech. We normally think about free speech as the right to talk or to speak, like I'm doing now. Some of you may be rethinking whether there should be such a right, but we normally think about government stopping people from speaking, but the compelled speech doctrine, going all the way back to a 1943 case, which said public schools couldn't force students to salute the flag, and a 1977 case that said New Hampshire couldn't force a pacifist to allow the state motto, "Live free or die," to be on his license plate. The idea is the right, free speech also means the right not to be forced by government to speak views that one doesn't agree with. And you can see that the court in 2018, not too long ago, extended and revitalized that right to deal with mandatory agency fees for non-union employees and a regulation of crisis pregnancy centers, et cetera. So anyway, it's an active area of free speech. And although, as I said, free exercise of religion is not technically at issue, there have been recent cases in which the court has found that laws that were like the public accommodation laws neutral, they didn't pick on religious observers, but they had discriminatory effects or they were applied in a discriminatory way. And so that's involved here in the background. In the interest of time, I'm not going to really go through these issues. You're welcome to delve into them and get value from these slides. But basically, the speech arguments are pretty straightforward. The argument is that government is compelling speech or in favoring some speech, but not other speech based on its content, and therefore it has to have a compelling interest, and the law has to be narrowly drawn to do that, and it doesn't meet that test. One of the big issues that the parties fight about in this case, by the way, is in being forced to do a website design, is the government really forcing the designer to speak or to associate herself? There was this very interesting conversation at the Supreme Court oral argument from the different justices saying, well, wait a minute, I look at a website on a wedding, I don't think of the designer as speaking, I think of the couple as speaking. They're sharing their story and when they met, and et cetera, et cetera. On the other hand, Lori Smith and the people that support her claim that, in fact, that inevitably if she's being asked to put the name of her company and her name on a website that speaks about a same-sex wedding, inevitably she's being drawn into that and will be deemed to be supporting it. So that's one of the key free speech issues that will get resolved here. Skipping over all these things, let's talk about the main takeaways. So this is unfortunately yet another example of a lack of judicial restraint on this Supreme Court. They kind of reached out to take this case. By some technical standards, there's a good argument that it's not ripe yet because Lori Smith hasn't tried to violate the Colorado law and been sanctioned. Colorado says there are alternative solutions. She could put a disclaimer in saying, you know, I do not agree with, I did this because Colorado makes me, I don't agree with these methods, and that should have been dealt with by the Colorado Commission. Court went ahead full bore and took the case. Ultimately, it also gets down to whether there will be limitations on equal market access for sexual orientation minorities due to religious and maybe other principled objections. The bold point at the bottom, of course, is it's going to be hard for the court if they, as appears they might, if they establish that in this, quote, limited context, religious believers have a right not to engage in goods and services if they disagree about sexual orientation minorities or same-sex marriage. But what if they disagree about interracial marriage or the right of women? I'm not going to do a website for the retirement party of a woman executive because my religion tells me women shouldn't work or shouldn't be prominent or something. How far does this compelled speech doctrine go? And of course, what that means is, how do we tell when someone's an artist or bringing enough creative distinction to what they do that they are covered by this? Not everybody, to use the wedding cake example, because it's a bit easier to see, Jack Smith, the party in the Masterpiece Cake Shop case, was a cake artist and he designed things specialty. On the other hand, your neighborhood grocery store that sells ready-made cakes is not really a baking artist. A website, a standard website template that is adapted by the people that are involved doesn't have probably enough artistry. But where do you draw the line? And that's why I'd say that could have a big impact on other free speech cases, free speech doctrines. So in just a couple of minutes that remain, I want to let you know about, remind you that, I think we even talked about this last year, that the Supreme Court has made a major change in the gun control Second Amendment law by making it clear that the right to keep and bear arms isn't just confined to the home, which is what the past cases were about, but includes having guns in public places, not sensitive public places. Those are still exempted, but concealed weapons permits publicly, etc. And that in this case, what we're going to use as the watchword for whether a state current regulation is allowed or not is not some level of scrutiny like, does government have a compelling interest or an important interest, or how real is the concern about gun dangers, especially in an urban area, et cetera, things that, again, the league is going to be talking about fairly soon at your lunch. But let me just talk about the standard that the court basically says. The court says that, I'm sorry, I'm flipping over a lot, obviously, here. But they said that there's two metrics that are dealt with here. Sorry, I'm trying to move my screen here a little bit. There's two metrics. First, whether the modern regulations impose a, quote, comparable burden on the right to armed self-defense. So what we're looking at the history and the tradition of gun regulation in the founding period, and does the modern law that's under review and under challenge impose a comparable burden or a higher burden? And then is it comparably justified? And those are both very malleable terms, but they're also, you know, past focused. And so you get, sorry, why am I not able to advance this? Oh, okay. You get, for example, Justice Breyer in his dissenting opinion saying the court today severely burdened state efforts to address some of the dangers of gun violence. We always see current controversies and current tragedies that show us the gun violence issue, but states are trying to deal with that and it severely burdens them. In my view, the court wrongly limits its analysis to focus almost exclusively on history and refuses to consider government interests that justify a challenge regulation, regardless of how compelling those interests may be. He thinks it's contrary to the Constitution and contrary to the precedents. But notice that is from his dissent. So what the majority has said is we're going to decide all these cases based on history and based on tradition and based on our weighing of the comparable burdens and benefits. Let me just very briefly share with you the headline of an article, if I can quickly bring it up here. Oh no, fumbling around a little bit. It's a story from the LA Times by a San Diego reporter, and who I've had the pleasure of working with, and I'm sure he wouldn't mind me using his article as a way to make this point, but he's basically talking about, after the Supreme Court's gun ruling, which I've just talked about, the Second Amendment groups now in San Diego that have brought past cases or have cases pending are looking at this as an opportunity to do a real do-over. And basically, a lot of that doing over is going to come before San Diego judges, and specifically U.S. District Judge Roger Benitez. The article goes on to point out he's called Saint Benitez by gun rights advocates, because he consistently favors gun rights and is has authored some of the edgier opinions in this case. But just look at some of the local and state gun laws that might be implicated in this reevaluation under history. Laws that outlaw homemade firearms, that ban assault weapons and large capacity ammunition magazines. Laws that restrict gun purchases based on a buyer's age and restrict the frequency with which people can purchase. And another article by this journalist just pointed out that very recently, two judges, a different San Diego judge and a judge farther up the coast in California, invalidated major portions of California's handgun regulation law under, again, the new standard. So I'm going to stop because I am out of time for my presentation. However, happy to answer any questions about any of this or anything else on anyone's mind. And again, thank you for the gift of your listening. I appreciate that.
Thanks to both Dan and Glenn. I have to say my head is very full after all that information, but it just really gets me thinking. So I want to encourage attendees to put questions in the Q&A at the bottom of your screen. You can just click it and add some questions. And Kim and I will alternate choosing questions. Kim, do you want to go first? Or do you want me to?
Sure. Yes, we have a question here from Mark Evans. It's for Dan. It says, isn't there a good chance that Moore v. Harper will be mooted? The North Carolina Supreme Court has a new member and is now poised, having agreed to rehear the case, to overturn its prior ruling and uphold the gerrymandered map.
Yeah, I'll give a little background on this, which the question kind of indicates, which is that when we won our case, there was a Democratic majority on the court, and it was a party line vote in which we won. In 2022 election, Republicans took control of the state Supreme Court, and our opponents in the case, the Republican legislators in North Carolina, immediately asked for a rehearing after the election, and they wanted to take the new state Supreme Court out for a spin. And there was a rehearing. We could have a decision, in the next few weeks. If it goes our way, if the federal court case will sort of move forward, I think, because there's not any sort of change of status quo. If it doesn't go our way, if the previous decision from a few months ago is reversed and the legislator's map is upheld, then it'll be up to the U.S. Supreme Court to decide whether that moots the case or whether they still want to decide the underlying issues, the radical independent state legislature theory. The U.S. Supreme Court did ask for a briefing on it, and we filed some briefs, and so did the other side, about whether we thought that this should moot the case, and we'll see. Yeah, we don't know, but it is possible. Yeah.
Okay. Oh. There's so much in what they will or won't agree to hear, it seems. So I have a question for both of you, and I think this comes a little bit out of my experience of the Dobbs decision. How much does it matter who writes the case and how it gets written, the decision, I mean, and how much does it matter how much, where there's a split, what the dissents are? Any thoughts on that? Because are there ways the Supreme Court can kind of fudge the issue in the decision?
You want to give it a shot, Lance?
Yeah, I was going to say it's a great dynamics, Supreme Court dynamics question. And often the way opinions are written reflects the doctrinal split, and sometimes even an ideological split on the court. If you've got a majority that really wants to decide the case aggressively, like in the Dobbs case, then pretty much you get an assignment to someone who'll take that on. A lot of times you get a 5-justice majority, but you only get that by having 1 or 2 members of the majority who are kind of have a narrower view or partly on board, but won't go too far. And often it makes sense to pick them to write the opinion, because it keeps them in the majority and reflects that nuance. So, and the same thing sort of on the dissent. It used to be, if you go back several decades, everybody would write a dissent. But one of the legacies of RBG was that she tried to get the dissent to unify behind one dissent in major controversial cases, so they wouldn't be watering themselves down. And that gets to your last point, Jane, which is, I'll just say very briefly, I think it does matter how large the dissent is, how strong they are. Do they paper over the differences and say, well, this, we all are pretty much in agreement, but there's minor differences? Or do they sound a clarion call that this is a tragedy? And it makes a difference, both in terms of immediate perception of the case and down the road. So sorry, I didn't mean to get carried away, but that's one of the issues I love to teach about in my Supreme Court simulation classes and other classes. So.
Dan, do you have any commentary on that?
No, I mean, I think that really nails it. I think you will see, you'll sort of people who watch the court closely, you'll be able to kind of discern some, sort of compromise, based on, like the who will join, because a decision is narrow. And I think you may discern from oral arguments that some justices wanted to go further, but were able to pull on others by keeping a decision more narrow. And you can kind of read between the lines at times.
Okay, thanks.
Thank you. Back when Glenn was talking about the case in Colorado regarding the wedding website, we had a question come in from Ann Knoll about that. And she said, by using the term religious freedom, where is the reference to that religion being Christianity?
Oh, well, it's a great question. Technically, it's not a reference to Christianity. Anyone who has any sincere religious belief, whether it's based on Christianity or Judaism or Muslim or anything, Buddhism, it should be accommodated to the same extent. There, of course, is both a narrative that U.S. is a Christian nation and some indication that the court is more sensitive to free exercise when Christianity is involved. but that you can find cases that dispute that as well. So there's not, in fact, if the court tried to have one rule for Christians and one rule for everybody else, that would probably itself violate the other part of the Constitution, the Establishment Clause. So we're talking about religion, but what is interesting, and I thought maybe that was included in the question too, is we're talking about arguably privileging or favoring people that have religious objections as opposed to moral philosophical objections, or a company that just doesn't want to spend money on birth control. Why should their objection is not going to be accommodated compared to an employer who works for affiliated with a religion that has a view about birth control. So it is an interesting privileging of religion generally.
Okay. The next question is there any move to lessen partisanship in courts so that the public can feel that their decisions aren't so temporary? I don't know if there's a way to lessen the partisanship.
Well, I'll just mention from the perspective of a judicial politics class that I teach. Obviously, you could go from an election process to a merit selection process or some other kind of selection process. Is one of the things that Dan's telling us about, and Mark's question about the switch in the Republican or the North Carolina Supreme Court majority tells us is those are elected positions and they're very politically sensitive and all that. Nothing would prevent North Carolina from adopting a less political selection process, except that politics probably makes that unlikely. It seems elections seem very durable, and I don't detect a lot of changes over time in that. If not that, then it really becomes either internal to the court, a shared sense that, hey, we need to dial down partisanship and accommodate the perception that we're overly partisan, or we, the public, or our elected officials, pushing back on that.
Yeah, I mean, I think the recent state Supreme Court race in Wisconsin demonstrates what how ugly it can become, how sort of nakedly partisan. Yeah. With the sort of finishing touch on that being the losing candidate's very angry concession speech, not conceding that his opponent was worthy of a gracious speech, and when you have big money in these races and they're elected, partisanship plays an unfortunate role.
Yeah.
All right, we've received a couple questions about Supreme Court justices and their ethics and accountability. I guess you probably figured that would come up tonight.
Yes.
Do you think that ethics issues surrounding the court will impact how far they go in their decisions?
Well, Dan, do you want to start with that, or?
If you have some thoughts, go ahead. That's hard. Go ahead.
Yeah, I know these are great questions, but
Yeah.
they're large questions, right?
Right. Yeah.
And process questions, but as you would expect from this group, the question I believe was worded: do I think they'll be concerned? I long ago decided that I want to be pretty limited in trying to predict how the court will react, but I'll tell you how they should react. They should be more concerned. They should be, this court, even a life tenured, non-elected Supreme Court depends, as Blanche Dubois says, on the kindness of strangers, or at least if not the kindness of strangers, the tolerance, the kind of acquiescence of not only the public and the perception that the court is ethical and less political and all that sort of stuff, but the public officials who determine their jurisdiction and their structure and all that sort of stuff. So they ought to be concerned about this. They ought to be very concerned about the recent revelations about Justice Thomas. They ought to be very concerned about recusal issues. They made a minor, self-regulatory attempt last month, but there's a lot more for them to go. And I think it does need to come internally because there are some real separation of powers issues if Congress tries to legislate about the court or force them to change their ethical rules. But certainly disclosure could be changed, and the court could be individually and collectively more responsive to the idea that there are, they not only need to avoid actual bias or conflict, but the appearance of bias or conflict.
Yeah, I mean, as Glenn sort of alluded, it's worth noting kind of explicitly that there is a strong code of ethics that basically all federal judges are required to adhere to, except for the U.S. Supreme Court, and that's a huge problem for perception purposes for the administration of justice.
Yeah.
Yeah, Dan, I'm sure your group deals with that with recusals. You probably from time to time weigh the idea that one of the justices or judges so out there on a position that they should be removed, recused from the case. But if you ask for that, it's up to them ultimately, and they may get annoyed. So, you got to weigh those kind of litigation strategy questions.
Yep. That's why I'll just stay quiet about that one.
Aggression is the better part.
Yeah. So here's a question directed to Glenn. Glenn, if you were a betting man, would you bet on the Supreme Court overruling Grutter and holding that race-conscious college admissions are unconstitutional for public universities and unlawful for private universities that accept funding, federal funding?
Yeah. I'll take on the hypothetical that if I were a betting man, if I were betting, I certainly would not bet on the Supreme Court. I have a long and ignominious track record of predicting the court, but I do think that I would bet, if I had to, I would bet that they will overrule Grutter, based more on the kind of the oral argument. Before that, I had hoped that maybe after all the pushback on overruling the abortion cases and all that, they'd go easy, and they'd take advantage of the fact that they could still rule against Harvard and University of North Carolina and significantly make the rules more restrictive without overruling. And that might be something that would look attractive to them. It still might, but I think it's if I had to bet, I'd bet that we're going to see our second overrule and, significant blowback about another important area of public policy. But you can email me if I'm wrong and go, ha, 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 there you go again. Comes with the territory.
Okay, we have a question from Faye Detsky-Weil. How does overturning so many cases change law when law has always been so respectful of precedents? No good answer.
Yeah, sort of.
I mean, the short answer is it changes it in a bad way. It makes it unstable. It makes it, it makes people like Dan and Common Cause and the League and all that who want to litigate less certain that they can at least rely on precedents, being durable, even if the current majority on the court wouldn't have decided that initially. I mean, at a certain point, respect for precedent is very important. And so that's why I'm not only concerned about the outcome of, say, the Grutter case, but also, I mean, the case about Grutter, but how they get there.
Yeah, I mean, it certainly generates cynicism about how justice is administered. I mean, what happened in the North Carolina Supreme Court, where a new partisan majority results in them agreeing to rehear a case they just decided on. Makes people concerned that these are sort of it's just politics by in another venue. So it's it's problematic.
Yeah. I have a question, since we have you held captive here, and it relates to the sort of recent news about the ruling about mifepristone, the medication, abortion medication. it just from what I've read, it seems that there is a question as to whether, there really is jurisdiction for the Supreme Court to even hear it. Anyway, I was wondering if either of you have some commentary on the mifepristone and the Supreme Court.
Okay, Dan, I'll take it away. I certainly do. So first of all, it's a great example. I just used it the other night in my judicial politics class about, two different district courts basically putting FDA in a diametrically opposed situation. You must do this, you can't do that. And it points up problems that, among other people, Justice Thomas has been raising about district courts issuing nationwide injunctions, or at least circuit-wide injunctions and those kind of things. So it's interesting from that standpoint. What you're referring to, Jane, is there's a big question about standing, whether the parties even have enough of a distinct stake to challenge a 20-year-old decision. The claims of doctors that they're going to be injured by the existence of that drug and the use of that drug are very speculative, and the court generally has some strong rules that I know Dan's familiar with about how speculative the injury claims can become. So there is that whole question about that, and we shall see. Maybe the Fifth Circuit is going to slow this down in a way and tell the Texas judge that his opinion should be put on hold. But ultimately, it's a case that at least the Supreme Court would likely consider, given the conflict between the two courts and the weird position it puts FDA in.
Any comment from you, Dan?
Well, if I remember, this was the case where there was kind of the easiest forum shopping ever, I think, right? There's some district courts that have an array of district court judges where, you don't know who you're going to draw. But in this case, I think there was a 100% chance of getting the particular judge they were targeting. And, that sort of seems problematic, again, from the perception of the court's fairness. Seems problematic to be able to shop that way.
Yeah.
Agreed.
Okay, we've got another question. In future judicial confirmations, what should judges be asked instead of questions about their respect for precedents?
I would ask that, by the way. I'm sorry, go ahead, Dan. I just say I wouldn't. I think it's becoming an increasingly important question to ask. So, but I would also I'll just say briefly, I would. I think we get too hung up on these hot button issues, and games are played to try to get them to feel out where they're going to go on these particular issues right now. We should keep in mind that we're naming someone to the court who may be on the court for 20, 30, 40 years, and the issues they deal with eventually, we may not even be able to foresee. So really, it's kind of what kind of judicial temperament do they have? How do they philosophically decide cases? Are they ethical? All those questions, I think, are things that if I could wave a magic wand, I would have the Senate focus more on.
Yeah, I think I'd want to know what their commitment is to fundamental voting rights. To what extent they understand that setting the rules for elections makes it difficult, in some cases nearly impossible, to hold those elected officials accountable at the ballot. It creates this contradiction. So it's clearly kind of a failure of representative democracy if you can manipulate the rules and then kind of elect yourself forever. So I would definitely want to know, nominees' view on fundamental voting rights and the court's power to act and protect them.
Yeah, that's a really good point, because it points out that sometimes a lot of constitutional and legal rights are important in their own, area, but some rights like voting rights and free speech are sort of foundational. They create the ground under which all the rest of these rights are exercised. And it's a very, as you say, it's very important to be dealing with trying to make voting and democratic participation as conducive to the other rights as possible.
Yeah, I mean, a familiar trope of our opponents who believe that legislators should get to manipulate voting maps for their own purposes. A popular trope of them is to say that, well, if you don't like how a legislator voted on redistricting maps, you just vote them out. Well, the very purpose of manipulating voting maps is to make it difficult or impossible to vote somebody out. So it's clearly a space where the judiciary needs to be involved and intervene to protect voting rights.
I have another sort of broader question, and I think this is a little more directed at Dan, but Glenn may have some comment. It does seem to me that the very conservative right has been very strategic about which courts they file cases in, and sort of knowing which courts are likely to rule in a conservative direction. And I was wondering, especially if Common Cause has, A is feeling the effect of that, but is how to if there's any way to address it.
So it's not something we've dived into a ton. I mean, we end up sort of filing our cases where we need to, right? Where the most egregious gerrymanders have happened is where we sort of try to get involved. But yeah, like I was kind of discussing earlier, I think that forum shopping is an issue that really generates a lot of cynicism about the process. We end up having to sort of go where the gerrymanders happen. We got to chase the nonsense. So we got to file where we got to file usually.
Yeah.
Yeah, I think that
right,
covers what I would say. Go ahead.
Thanks. We have a question from Jeannie Brown, who says that Ruth Bader Ginsburg shared that in the earlier voter rights weakening, that the court was acting like a person with an umbrella, saying that rain wasn't a problem or something like that. Is that what the court is doing this time too?
Yeah, it's interesting, that it turned out when the Roberts Court struck down the most key oversight provisions of the Voting Rights Act, right? The formula that allowed for pre-clearance to determine whether a voting map was discriminatory, whether a change in election rules was discriminatory. It used to be that you would pre-clear these things either with the Department of Justice or a district court, usually DOJ. And this was the formula to determine who would have to do it was really focused in on previous bad actors, right? A lot of southern states and counties and other parts of the country that had a history of discrimination. And, essentially the majority decision striking down that pre-clearance regime said, there's not really a problem anymore. We're picking on these jurisdictions from actions they took, decades ago. And then that was an invitation to political scientists to kind of follow up on that and determine, were these jurisdictions in fact suddenly good actors? And as it turns out, most claims filed under Section 2, where you have to sue after the fact, it's not pre-clearance, it's something discriminatory happened and you have to then go to court and challenge that, either a voting map or some other change in election rules. The same jurisdictions that were originally covered were in fact still the bad actors that had the more successful Section 2 claims filed against them. So, the late Justice Ginsburg was right that it was a problem. In fact, the pre-clearance regime was protecting voters in places that were in fact still acting in a discriminatory manner, proven by the data post Shelby County, the decision that struck it down.
If I can just add a post note to that, not on the subject that Dan very well covered, but if correct me if I'm wrong, Dan, but I think that decision you were describing was a decision, one of the, if I recall, Chief Justice Roberts said, oh, but Congress could always fix this and come back with a pre-clearance standard that would be constitutional. And I think that's something that all of us as citizens, and especially the League of Women Voters members, need to keep in mind, that we always focus on what the court rules on, but often there's also, like with campaign finance and other kind of things, there are legislative solutions and political reforms that we can try to support. Now, as you point out, Dan, if the system is circular and prevents access to the very system that would need to reform it, that's a big problem. But sometimes there are, solutions outside of courtrooms. And so I think it's an important theme for people to keep in mind.
Yeah, it's true. It's difficult, but definitely, there is hope. I mean, for it, Congress in the last session passed John Lewis Voting Rights Act and some protections for the first, that would have created independent redistricting commissions in every state. It hit the filibuster wall in the Senate, unfortunately, and some other opposition. But it's progress, to at least pass out of the House. We've just got to keep at it, keep pushing.
We have a few more questions coming along. This is from Miles Pomeroy. As a follow-up on gerrymandering, I was very surprised when the Supreme Court okayed extreme gerrymandering in 2019. How can that be justified?
Well, the case was called Rucho v. Common Cause, so I don't think it was justified. We were the party, like I mentioned at the front end. It was over a very passionate dissent from 4 justices that Justice Kagan wrote. There were, again, the district court in that case, the lower court case, found a way to determine what a partisan gerrymander was. Also making their way up through the courts when that was decided was in Michigan, a partisan gerrymander was struck down by a federal court. In Ohio, a partisan gerrymander was struck down by a federal court. And somehow those district court judges found it in them to find a solution to determine when gerrymandering went too far and offended the Constitution, but the Supreme Court disagreed. That's how it goes. So that's why we went to the states, and we're gonna keep fighting, keep at it.
Yeah, I teach this. What the court would say is, and did say in Rucho, was that because unlike racial gerrymandering and numerical gerrymandering, partisan gerrymandering is not per se unconstitutional. We've always had manipulation of districts. It's as American as apple pie, a disputable point, but that it's only, as the questioner said, when it's too extreme, and there's just not a judicially manageable standard for what's too extreme. Judges have to act like politicians. So as an aspect of the political question doctrine, which is not to say it's right, but that's just if the questioner was looking for what's the rationale, that was the rationale that was given.
Sorry, it gets me too riled up. Can't get to the
understand. You should
legal doctrine.
You should not have to speak that position, Dan. But I'm a professor. I sometimes have to look at both sides of the out of my mouth here.
I appreciate you.
Thanks.
All right, we have 2 more questions back to the ethics issue, asking how is it possible that Supreme Court justices don't have to meet ethics standards? And what about the Article 3 wording says that they must hold their offices during good behavior?
Go ahead, Glenn. You sort of alluded to what are the questions, sort of the separation of powers. You should.
Yeah. It's really about that. I mean, the short answer to the question is the good behavior standard, and whether and what it requires, in addition to not committing an impeachable offense, which itself also is hard to define sometimes, is just up in the air. It's just not resolved. So it's not a really good, strong basis for arguing that. And as Dan said, federal judges are under ethics rules and disclosure rules and misconduct procedures and all that. But the Supreme Court, partly because of its unique position as a equal branch to Congress, and partly because if the Supreme Court, you could affect the outcome of a Supreme Court decision by forcing a justice to recuse themselves, or by manipulating a claim that a judge is committing misconduct in a way that doesn't work for lower courts. And so for that, and because of just the separation of powers concern, Congress has always been very reticent to legislate. I think hoping the Supreme Court would self-regulate, and I still hope they will, and they should. But also, as you becoming more aware, various members of Congress are definitely proposing more bills, and it's becoming more of a hot item. I don't think it's something the Supreme Court can just sweep under the carpet.
Okay, I think we have one more. We've gotten everything we can get out of the two of you, I think. But one more. So what sort of mechanisms are in place to help voters better understand the pipelines that justices pass through on their Supreme Court trajectories, and how they got there, what their qualifications are? Any thoughts on that?
Well, that's what, of course, the confirmation process is supposed to dredge up. And I think it does a pretty good job of at least dredging up the factual information. What can't be known is, because it's not disclosed, is what's the role played by interest groups and, donors and political associations and members of Congress and all that in terms of influencing and pushing particular people or opposing other people. The previous administration did go past a barrier in actually installing the Federalist Society and its executive director in the White House to deal with judicial selection and all that. We haven't had it something quite that overt before. But I don't know that they, so I don't know that the public found out about that at the time, but a lot's coming out about it. So it's like anything, Jane, it's how, do organizations like yours and public officials and reporters and all that point it out, and do the voters care and, consume the information and that kind of thing.
Wow.
Yeah, I know that one sort of sign, positive sign for how a pipeline may look going forward was Justice Ketanji Brown Jackson coming from a public defender background, right? I think sort of informally there was a background of Ivy League, corporate law, to the sort of appellate bench, or maybe a stint at the district court, but it was nice to see a change of pace. So there's sort of diversity of all sorts and diversity of backgrounds where a person may have some empathy for all sorts of folks who may come before the court. That was a welcome change.
We do have one follow-up question on extreme gerrymandering. And then also, I thought maybe I'd also see if either of you have any general parting reflections for us, in particular about what role the league can play with any of this. But on the extreme gerrymandering, why wouldn't that be considered a violation of the one man, one vote principle?
So the one person, one vote principle generally kind of came up in earlier cases in the starting, or primarily in the 60s, were about equal population. It's not, so the tack we decided to take was sort of less about that, and more about sort of how the discrimination against one party's voter was offensive to First Amendment free association, it was offensive to equal protection. So I think that there would have been a case to be made on one person, one vote, but that was kind of a lesser prong of our approach, which was more based on the First and 14th Amendment.
And any final reflections for us?
I guess I can go. With a court that is not particularly friendly to voting rights, or hasn't been in a few famous decisions, I think it's kind of easy to be frustrated, be cynical, and I think I've used the word cynical a few times in this presentation. But one thing I should just note, so I've been kind of in this area redistricting for kind of 9 years. I think Jane mentioned at the front end. There's been a huge change in kind of public consciousness about the ability of the public to make a change, vote people out of office, hold elected officials accountable because of gerrymandering. And that has pushed reform in the states, people who are have gotten active to pass ballot initiatives, to shame legislators into making the process less partisan, more transparent. And it's also changed judges. The state courts striking down partisan gerrymanders didn't come because somebody, put on a seminar at Yale. It came from angry people knocking on doors and making themselves heard at legislative hearings. So the problem may feel intractable, but the activism of folks like all of you listening in has been essential and done good. So thank you for what you're doing.
Any parting words from you, Glenn?
Well, I was going to go there where Dan went, but just more generally, which is that it's very easy to get discouraged and cynical or outraged at a current Supreme Court or a current district judge or whatever. But I think it's important that people, keep standing for the fact that judges just shouldn't be politicians who wear a black robe, and that's not something we should accept. And to elect people at all levels of government that are sensitive to that and keep that issue alive, like Dan was saying. I just think it's very important that we not lose hope, and that it's almost like if you get thwarted in one place, go somewhere else. I mean, that's been the history of up and down, where sometimes the Supreme Court has been more rights focused and more rights oriented, and you went there rather than the states. And sometimes the court has been more resistant, and you go to states and try to argue under the state constitution that they're rights. And that's why this Moore case is so important. But I guess, don't get cynical. Keep going, because it's really worth it.
Well, I want to thank you both. You've just given us so much. I'm going to go back over the recording just to try to absorb more of the details. And I feel more prepared to listen to what does come down from the Supreme Court. Just very thought-provoking. You were a dynamic duo too. And thanks. We look forward to talking with you more. And thanks to all the attendees for coming and for the very good questions.
Okay.
Thanks, Dan and Glenn.
Absolutely.
Good night, everyone.
Night.
Take care.